Okay, hello and welcome to the final of the Speed Mooting Plea Mitigation Competition 2023 in partnership with BPP. I'm John Dove and I'm the founder of the National Speed Mooting Competition. So we've been progressing through the various rounds today. We've been through round 1 and round 2, and we are now up to the final. So we're going to have our 6 finalists competing against each other for the prize of being the winner of our Plea Mitigation Competition 2023. So up first, we have our first competitor, who is Aithne Moran. So in your own time, when you are ready.
If it pleases the court, I am Miss Moran and appear on behalf of Miss Mack. Your worships, prosecuting counsel has already submitted that this is a Category 1 offence due to a breath reading that was significantly over the legal limit, which we do not dispute. But I do intend to persuade this court that there are mitigating factors that make a high-level community order combined with alcohol rehabilitation the most appropriate sentence. This is supported by the pre-sentence report, and before I proceed, do your worships have sight of that report? I'm grateful. In my submissions, I will outline the sentencing guidelines, Miss Mack's prior offences, and personal mitigation that would make a custodial sentence unjust. First, your worships, as Miss Mack's offence falls into Category 1, the starting point is a 12-week custodial sentence. But the bracket does range from a high-level community order to 26 weeks in custody. And in any event, a 36 to 60-week driving disqualification will apply. There are several potential aggravating factors: that there was a passenger in the car, that it was raining, and there was an accident. However, it should be noted that this was a single car collision on a quiet country road away from any residents, and there were no injuries. With respect to Miss Mack's 2 recent drunk driving offences in the past 5 years, I submit that these prior occasions can be distinguished and are less relevant, wherein Miss Mack drank with the intention to drive and was slightly over the limit, whereas in this offence, Miss Mack was further over the limit and hadn't planned to drive at all. She drank only as she had a designated driver who unexpectedly refused to drive her, and then she erred in her judgment due to the level of her intoxication. Miss Mack is aware that she faces a mandatory driving disqualification and may face a custodial sentence. And to her credit, she pled guilty at the first available opportunity, allowing a 1/3 reduction to her sentence, and has cooperated fully. She is deeply remorseful and is under no illusions about how grave her offence was, which she will never repeat. And I submit that there are 3 points of personal mitigation that highlight future harm to Miss Mack's family and the community if a custodial sentence were imposed. And this makes a high-level community order more appropriate. First, despite her recent offences, Miss Mack is committed to charitable works. Just this month, she ran an event for a local charity which raised their entire operating budget for the year. Her fundraising would halt if she was sent to prison, and so too would her career as a celebrity, as her brand deals would be withdrawn. Now, I do not submit that a celebrity should be above the law, but I do submit that it is relevant that a loss of sponsorship would reduce the money that she can raise for the communities that charities serve. Second, Miss Mack is the primary carer for her 3 young children. She has no relationship with their fathers. So when she works, her elderly mother takes them, but due to her age, she can't watch them for more than a few hours. There are no other family members that her children could live with, and Miss Mack is deeply distressed about what would happen to them if she were sent to prison. Third, Miss Mack acknowledges that she does have problems with alcohol that coincide with her rise to fame and the stresses of her career. And this is why she has 2 recent similar convictions that impact on her character. She is fully committed to addressing her alcohol abuse, and this recent drunk driving accident has served to her as a wake-up call. I ask your worships to consider what would be gained from the financial harm inflicted on Miss Mack and the community by a custodial sentence. or indeed the social harm on her young children if they were without her carer at a key stage of their development. A community order would allow Miss Mack to give back to the community she endangered with her offence, to raise her children, and address her issues with alcohol. She wouldn't be on the road causing future harm, as a mandatory driving disqualification would apply. And if your worships are not with me on that, I would ask this court to consider suspending her sentence, as a suspended sentence would act as a reminder of the gravity of her offence, and it would allow her the opportunity to rectify her relationship with alcohol and to care for her children. And unless I can assist the court any further, that concludes my submissions.
Your worships, if it pleases the court, my name is Miss Natalie Alt and I appear on behalf of the defendant, Miss Mack. May I check that your worships received a copy of the pre-sentence report?
We have.
I am grateful. I'll first deal with the nature of the offence and then I'll move on to deal with the offender. Turning to the offence, this has a sentencing range from a high-level community order through to 26 weeks immediate custodial sentence. There is a starting point of a 12-week custodial sentence. The defence accepts that this is a Category 1 offence. My client is aware there is a risk of a custodial sentence. However, I respectfully request the court follow the recommendations of the pre-sentence report and impose a high-level community order. Now, I will address the numerous factors I submit the sentence imposed by the court should be of the lowest range. However, I respectfully request the court also consider the alternative of a suspended sentence throughout the remainder of my submission. As your worships will know, Miss Mack pleaded guilty at the earliest opportunity and therefore qualifies for a 1/3 reduction for her early guilty plea. As the aggravating factors that apply in this case, it is submitted that the main aggravating factor here is that Miss Mack has 2 previous convictions for driving-related offences. Miss Mack has only received her driving licence back recently. However, on both occasions, the alcohol reading was just above the limit at 41 milligrams for 100 millilitres. I submit that the aggravating factor is outweighed by numerous mitigating factors, which I will discuss later on. Your worships, you will see in paragraph 6 of my pre-sentence report, Miss Mack acknowledges her issues with drinking and is committed to take steps to rectify this issue. This is her first offence where there is a risk of a custodial sentence, which puts her livelihood at risk. This is why this particular offence hits home to Miss Mack, and I submit that there is now a significantly reduced risk that a similar or future offence will be committed by this defendant. Your worships, Miss Mack has been open and cooperative with all the police and the court from the beginning and has shown complete remorse for her offence. She was driving on the day purely as her friend was fearful to drive due to the weather conditions. Miss Mack resides only a mile away from the party and took the decision to drive home. However, Miss Mack recognises the danger she imposed to other road users and also accepts that what she did was impulsive and foolish. Turning to the offender, there are several mitigating factors relevant to Miss Mack. Firstly, Miss Mack has a career in television. She is also a social media influencer. She was successful and is concerned the impact a custodial sentence may have on her ability to financially provide for her 3 children. She is the sole mother and there are no father figures in the life of the children. And this brings me on to my second point, your worships. Miss Mack can only rely on her mother to look after the children. Her mother is only able to do this for a short period of time. Therefore, if Miss Mack went to prison, her mother could not care for the children. Additionally, she has no immediate family members who would be able to assist with childcare. Therefore, to place Miss Mack in prison would place her mother and her children at a significant disadvantage. Finally, your worships, Miss Mack is committed to charitable causes. She often organises and takes part in fundraising events, and to impose a custodial sentence would prevent her from fulfilling any commitment she has already made to charitable causes. Additionally, it could affect her reputation, and which could impact then her undertaking for meaningful charity work. To conclude, your worships, in paragraph 9 of my pre-sentence report, the recommended sentence is a 12-month community order with 200 hours unpaid work and 10 rehabilitation activity requirement days. This has a focus on her alcohol misuse as well as her thinking and behavioural skills. I respectfully submit that this is the correct sentence to be imposed on the basis of the mitigating factors that I have discussed above. It is a matter for your worships to come to the decision on how many hours Miss May should undertake. However, as she has previously done and will continue to do, she will engage in any sentence that is given to her. If it is the court's view that a custodial sentence must be imposed, I would respectfully request that the court instead impose a suspended custodial sentence. This will enable Miss Mack to be able to continue to support her family and also continue in her charity work. Unless I can assist the court any further, those are my submissions.
May it please the court, I appear on behalf of Miss Mack. Before I begin, your worships, may I check that you have a copy of the pre-sentence report and that you've had an opportunity to consider it?
We have.
I'm grateful. I intend to address the particulars of the offence having considered the sentencing guidelines. I will move on to Miss Mack's personal circumstances, which I invite the court to consider. I agree with my learned friend's submission that this case falls within the top bracket, as the reading clearly falls within its range. I'm inviting the court to follow the recommendation of the pre-sentence report with a view to impose a high-level 12-month community order with 200 unpaid hours of work together with 10 rehabilitation activity requirement days. If, however, your worships consider that this case has crossed the custody threshold, then I invite you to consider a suspended sentence given the defendant's childcare and charity commitments. Your worships, Miss Mack fully understands the seriousness of the offence that she has committed. She recognises the danger that she posed to other drivers. She recognises that her decision to drive was both impulsive and foolish. She understands that she is facing a lengthy ban and a possible custodial sentence. However, she is genuinely remorseful for her actions, and she wishes to assure the court that in future, she will treat her licence with respect and will no longer drink and drive. I understand the court may be concerned with the presence of aggravating factors. It must be acknowledged that the defendant has 2 recent previous convictions for driving with excess alcohol. However, the court will note that Miss Mack received the minimum driving ban possible on both occasions. This was because she was only just over the drink drive limit. Turning to the current offence, it must be acknowledged that it was raining, that Miss Mack had a passenger and that she was involved in an accident. She had attended a party and had drunk 2 bottles of wine. In a short-sighted attempt to help her friend, she drove home. I wish to highlight that this is a rural area. There were no houses on the stretch of road where Miss Mack crashed, and there was only 1 car in the 20 minutes during which the police were present at the scene. I also wish to highlight the short distance that the defendant drove, less than a mile. It must be noted that there was no attempt to flee the scene, no attempt to disguise the fact that she was the driver, no attempt to conceal the fact that she had been drinking. In fact, the defendant was cooperative with police at the roadside and in the police interview. The court will, of course, be aware that as Miss Mack entered a guilty plea at the first opportunity, she is entitled to a 33% reduction in her sentence. I appreciate the court may be concerned with the fact that Miss Mack did not contact the police herself and that she made no reply to caution when arrested. It is submitted, however, that Miss Mack was in a state of shock, having just been involved in an accident. I turn now to Miss Mack's personal circumstances. She is the sole parent to 3 young children. Their father is absent. If she is placed in custody, they will undergo the trauma of separation from their mother and being placed into care. This would have a significant detrimental impact on them. There is no immediate family available to look after the children for a prolonged period of time. Miss Mack is committed to supporting her local community alongside her busy work schedule as an influencer. She is involved with several charities. She organises and takes place in some 15 events per year. Indeed, she raised £100,000 at an event just last month. If she was in custody, she would be unable to fulfill future charity commitments and would suffer reputational damage, impacting her prospects in the future. Alternatively, a community order would provide support she needs to address her relationship with alcohol, the underlying reason for her behaviour. She herself remains committed to do that. However, if the court remains of the view that this case crosses the custody threshold, I submit a suspended sentence is appropriate. This concludes my submissions unless I can be of any further assistance.
Good afternoon, Your Worships. If it please the court, I appear on behalf of my client, Miss Mack. Miss Mack has pleaded guilty to the offence of drink driving committed on the 1st of April. I respectfully propose a high-level community order as an appropriate sentence. If the court decides to impose a custodial sentence, then I submit, in line with the recommendations of the pre-sentence report, that a suspended sentence would be an effective alternative to a full custodial sentence. Before I proceed, may I confirm that Your Worships have been able to consider the pre-sentence report?
We have.
I'm grateful. I'll begin with the categorization of the offence, as I am not in dispute with my learned friend here. Miss Mack's alcohol level was recorded as significantly over the requirement for the top bracket of this offence, and thus placement here is suitable. This is a serious offence, and Miss Mack acknowledges this. I would like to emphasise Miss Mack's full admission of guilt. From her initial police interview to her first appearance in court and to today, she has expressed remorse throughout this time, understanding the dangers of her act and recognising that her relationship with alcohol has to change. I'll consider some aggravating factors now and how these can be mitigated. Miss Mack does have 2 previous convictions for drink driving, but I submit that both were in the lowest possible bracket for the offence, with an alcohol level only marginally above the legal limit. I submit also that she pleaded guilty for both. She has always accepted responsibility for her mistakes. On the event of this last offence, Miss Mack was carrying a passenger, Mr. Maryland, and she was driving in adverse weather in the rain. Although Miss Mack accepts full responsibility for her decision, I submit that Mr. Maryland, the sober designated driver, had refused to drive in the rain and recklessly encouraged a vulnerably intoxicated Miss Mack in making this decision. They were involved in an accident as the car crashed into a tree, but I submit that there were no recorded injuries. They were driving in a rural area with no pedestrians and no residential housing. Only one other car was spotted in the area over a 20-minute period. Fortuitously then, on the night, the harm from this serious offence was low. I will consider now some mitigating factors in their own right, underlining here again Miss Mack's remorse and her embarrassment at this reckless action. The distance of this journey was relatively short, only 1 mile between the venue and Miss Mack's home. I submit also that Miss Mack, despite her 2 previous offences, is an individual of good character. She is involved with various charitable organisations at both the local and national level. Thanks to Miss Mack's fundraising alone, one local charity recently had their entire year's running costs funded through her £100,000 raised. This was just one of 15 fundraising events that Miss Mack puts on in any given year. Any time she spends in prison means she cannot meet these future charity commitments and will be unable to fundraise at that time. Her ability to fundraise in the future after this custodial sentence will also be significantly impacted due to the compromising of her social media influence. Most important here, however, is Miss Mack's relationship with her 3 young children. She is effectively the sole carer for these children, aged 3, 6, and 12. Her 80-year-old mother does some light care work, but could in no way care for them in full in the absence of Miss Mack. There are no father figures. There is no immediate family who could take her place for this care. Were Miss Mack to face a custodial sentence, 3 young children would be left without any significant family support. To conclude, the sentencing guidelines propose a range between a community order and 26 weeks custody for this offence. I submit, given Miss Mack's admission of guilt and her mitigating circumstances, the terms of the 12-month order proposed in the pre-sentence report are suitable. This includes 200 hours of unpaid work and 10 rehabilitation days focusing on alcohol misuse. Miss Mack is willing to consider these recommendations and follow them, as they best facilitate her path to a healthy relationship with alcohol, the underlying cause of her offence. Ms. Mack expects and accepts significant driving disqualification will also follow from this offence with a minimum of 36 months. If the court is unwilling to consider this order, I submit that a suspended sentence is a suitable alternative, allowing Ms. Mack to live in the shadow of the consequences of her decision and work to change both her attitude and her lifestyle. She would be willing to do this, ensuring she stays out of prison and can continue to provide for her young children and work for the benefit of the community. Unless I can be of further assistance, that concludes my submissions.
May it please the court, my name is Mr. Purshouse and I appear on behalf of the defendant, Miss Mack, in this matter. Before I begin, may I please check that the court has received a copy of the pre-sentence report?
We have.
I'm grateful. Your worships, I will first deal with the offence and then the personal circumstances of Miss Mack. I respectfully request that the court follow the recommendations of the pre-sentence report and impose a high-level community order. It is not in dispute that this offence falls into the top category, the starting point of which is 12 weeks custody, and the range is from a high-level community order to 26 weeks custody. I recognise that there are aggravating factors in this case. Miss Mack has previous convictions, the driving conditions at the time were poor, and an accident was caused. I also accept that the antecedents were recent and for the same offence. However, the circumstances here were very different. In the immediate offence, Miss Mack acted impulsively, out of a desire to assist her friend, and travelled only a very short distance at a quiet time of night. The accident has given her a real wake-up call. Miss Mack fully accepts this was a foolish mistake and has shown genuine remorse. There is also significant mitigation in this case. Your worships, Miss Mack entered a guilty plea at the first opportunity, which, as the court will know, entitles her to a full 1/3 discount. Not only this, Miss Mack was fully open and cooperative with investigating officers in her police interview. I invite your worships to turn to page 11 of the bundle at paragraph 6. Are you with me?
Yes.
I'm grateful. This is the pre-sentence report. It shows that Miss Mack now recognises that the impact of fame has been disorientating to her and has led her to developing an issue with alcohol. Having recognised this, she will be committed to engage with the conditions a court might impose through a community order, particularly conditions that can help her to address this issue. Moving then to the personal circumstances of Miss Mack. She has 3 young children aged between 3 and 12 for whom she is the primary carer and sole financial provider. There is nobody in her family who could take on this caring role, and so the imposition of a custodial sentence upon Miss Mack would have acutely damaging impacts upon not only her but also her children. Miss Mack has used her celebrity profile for good, raising a lot of money in the community through her charity work. This will be heavily impacted by a sentence of imprisonment, as she will lose her links to several charitable organisations. Given the mitigation and collateral consequences that would result from a custodial sentence, I respectfully submit that a community sentence of 12 months with a 200 hours unpaid work requirement and a rehabilitation activity requirement is the correct sentence to impose in this case. I do not contest that in addition there will be a driving disqualification within the mandatory range. If the court determines that a custodial sentence is unavoidable, then I respectfully ask the court to consider suspending that sentence. This would provide a proportionate and imminent deterrent to Miss Mack from committing further offences without the wider family impacts upon her. That concludes my submissions, unless I can assist the court further.
Your Worships, I'm here today to ask you to follow the recommendations set out in the pre-sentence report and to not impose a custodial sentence on my client, Miss Mack. Have you had an opportunity to read the PSR?
We have.
I'm grateful. First and foremost, Ms. Mack pleaded guilty to the offence at the earliest opportunity and so should be awarded the maximum amount of credit of a third on any sentence imposed. Given her previous convictions for drink driving, Ms. Mack fully accepts that she will receive a lengthy disqualification from driving, but we ask a custodial sentence not be imposed for the following reasons. Ms. Mack has sole financial and caring responsibility for her 3 children, aged 3, 6, and 12. If I may refer you to paragraphs 3 and 4 of the PSR, the children do not have contact with their fathers, and Ms. Mack's mother, who sometimes looks after them, is 80 years of age and is generally unable to care for them for periods longer than 2 hours. Ms. Mack has no other immediate family members that can care for them either. If she were to go to prison, this would be incredibly disruptive for her young children's lives in what are formative years and cause disproportionate harm to the family. Further, my client intended to drive only 1 mile between her friend's house and her own home, and at 1:30 in the morning on the outskirts of Manchester, it's agreed that the roads were quiet. And yet, as stated in both paragraphs 6 and 7 of the PSR, my client fully recognises that she posed a potential danger to other road users, that she has an issue with drink arising from her relatively newfound fame, and that her decision to drive in the circumstances was impulsive and foolish. In this respect, she is deeply remorseful. She is keen to comply with the recommendations of the high-level community order set out in the PSR, including the rehabilitation activity requirement focusing on her alcohol misuse and her thinking and behavioural skills. We implore your worships to have confidence in Ms. Mack's remorse and in her commitment to comply with any community order imposed. Indeed, she has already demonstrated exemplary conduct, not only in response to police investigation of the charge before you, but also generally in her life and career. Ms. Mack never objected to the police investigation and in fact was highly cooperative and assisted them. On the night of the incident, she was the one to inform the intending police officers that she was the driver of the vehicle and not Mr. Maryland, whose car it was and who was at the time sober. And she did not object in any way to taking a breathalyzer and subsequent tests. And she also accepted during the interview that she had drunk alcohol prior to driving. These are the actions of someone who immediately knows that they have done wrong. Lastly, Ms. Mack has upcoming commitments to charitable organisations and sincerely wishes to continue to undertake the work to the best of her ability. If she were to go to prison, this would be impossible. My client uses her fame as a TV personality and influencer productively. She organises and takes part in around 15 fundraising events each year, and she has raised as much as £100,000 for a local charity in the last month alone. Ms. Mack's career is based on reputation. If a custodial sentence were to be imposed, not only would she be unable to fulfil her commitments, but her influence would suffer, and as such, this charitable work would suffer. It is in light of such exemplary conduct that a custodial sentence would not only be disproportionate, but not in the interests of a number of benefactors of Ms. Mack's charitable work. In summary, your worships, we ask, especially given the impact on her young children, that you follow the recommendations set out in the PSR and that a custodial sentence not be imposed. If the court is not minded doing so, we ask that the custodial sentence be suspended. A suspended sentence will act as a constant reminder of Ms. Mack's irresponsible decision that night, helping her to stay on the right path of reform and rehabilitation. Thank you for your time.